Oh yes, oh yes, oh yes. The Honorable Court of Appeals of Tennessee is in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning and welcome to the Tennessee Court of Appeals. Appreciate you all being here this morning. I think we've got 3 cases scheduled for hearing. Before we get started, I want to just basically touch on the procedure that we utilize. Obviously, each side gets 15 minutes to make its oral argument. If you are the appellant and you request rebuttal time from the court after you've introduced yourself, but before you begin your argument, you may reserve up to 5 minutes of rebuttal time. Obviously, the appellee gets no rebuttal time. A little distracted, I'm sorry. Also, I want to inform counsel that, and the parties as well, that these arguments are being live streamed. So keep that in mind as you make your oral argument. Before we get started today, though, I want to introduce your panel for this morning. We have Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. Miss Angie, anything we need to take up before we get started?
No, Your Honor.
You may call the first case then.
Louise Faulkner et al. Versus Nationstar Mortgage, LLC.
Yes, sir.
Good morning. May it please the court. I'm Attorney Terrell Tootin from Memphis, Tennessee. I'd request 3 minutes rebuttal time.
3 minutes. All right, sir, you may proceed.
This matter is, on a factual standpoint, pretty straightforward. The reason we're here today is because of the way the facts were ruled on from a legal perspective. Quite frankly, there's no real dispute that Ms. Faulkner, Louise Faulkner, and Ernest Faulkner both had a home that was, the mortgager was Nationstar, and at some point they had sold her home without her permission or knowledge. They basically secretly sold her home, found out as she continued to dispute and have concerns about what happened, she challenged.
Let me ask you a question, Mr. Tootin, because
Yes.
when I was preparing for this, I want to make sure that I've got the right understanding. They actually sold the real estate as opposed to selling the note. And
They actually sold the home.
Okay.
They sold it to a company called Blue Spruce Entities and sold it to them. And during this time, Ms. Faulkner was not aware because she saw someone put a sign on in her yard saying someone else owned the home, but Nationstar would deny it. She reached out to Tennessee Consumer Protection because she said, well, wait a minute, this is not making sense. I don't even owe the money, the amount of money they're saying that I owe. Something is very unsettling about this. Nationstar would again deny it and say, look, there's been no irregularities with this mortgage or anything of that nature, not alerting even Tennessee of the fact that the home was actually sold. And so what they then end up doing is somehow getting the home back from this sale, and then told Ms. Faulkner, hey, in order to remedy this matter, we're just going to release the home to you. So they made it as if they were releasing it to her free and clear, no harm, no foul. And then she later finds out that they put an adverse credit reporting on both her and her husband's credit report, which they don't dispute. That's not even a disputed fact. And so when we're having a trial on fraudulent conversion, the court was told the juries this is a matter of fraudulent conversion. We were told it was fraudulent conversion, and that's what the jurors had to decide on. But then the plaintiffs or the appellant was prohibited from talking about the fraud or the intent of Nationstar as related to fraudulent conversion. So Nationstar took the position of it is too prejudicial for us to be able to inform the jurors that adverse credit actions happened to both Ms. Faulkner and her husband, Ernest Faulkner. It is our position that that's what we call a bad fact. Yes, sometimes facts are not favorable.
Let me ask you a question. Did you allege adverse credit action in the complaint?
Yes,
Okay.
yes. So there was an original complaint and an amended complaint that adopted, the amended complaint adopted the original complaint. And then as speaking about fraudulent conversion specifically and talking.
Are you sure you alleged that in the amended complaint?
It's the amended complaint incorporated the original complaint, which is where the fraud came from. In other words, the fraud was laid out extensively in the original complaint with the adverse credit action, and then the amended complaint incorporated the original complaint and then added on the other issues of wrongful foreclosure. If you will notice on this court's initial order for summary judgment, the fraud component of fraudulent conversion survived based on the language from the original complaint. So the court adopted, as instructed in the amended complaint, the court relied on both. In fact, that was the basis of saying the claim of the fraud survived for fraudulent conversion was based off the language in the original complaint, which was again adopted.
Let me stop you here.
Yes.
Let's back up and perhaps you can enlighten me here. We're using words interchangeably here. Wrongful conversion, fraudulent conversion. Are those two different claims?
No. So fraudulent conversion is a claim, and fraudulent conversion deals with conversion and fraud. You have to, so to answer it that way, you have to prove fraud, which fraud by itself is a claim.
Okay.
But
Before
for
you get too
fraudulent
deep in
conversion,
this,
you have to prove both.
Are there two different claims? Is it just a conversion claim, or is it a fraudulent conversion claim, or is it a wrongful conversion claim?
There's different claims, so that's a good question. Anytime you have fraudulent conversion, you have to prove fraud. So fraud, the elements individual to fraud is separate. You have to prove that
Okay.
as a standalone.
Did you allege both?
Yes. So in the original complaint and amended, it's alleged both. So we had to prove fraud, and then we had to separately prove conversion in order to get the claim to answer a fraudulent conversion. So fraudulent conversion is a claim that has a standalone cause of action of fraud, and then there's a standalone cause of action of conversion, meaning we can end up not proving fraudulent conversion but prove conversion, or we can end up just proving fraud, but all of those are claims that we would have the right to prove. In addition to that, when it related to the adverse credit action, again, after it was determined that it was too prejudicial or harmful for the jurors to know that adverse actions happened to the appellants, which again goes towards the intent of Nationstar to remedy the matter, this brief explains how then Nationstar used that as a weapon, and throughout the trial was able to argue, well, look, Nationstar realized there was a mistake made, and they went in and they fixed this mistake, and they gave her the house free and clear. What else are we supposed to do? Well, that argument, not able to be challenged by the fact, wait a minute, it wasn't free and clear. After you acknowledge now that you've made a mistake and there's no question, you compound it by leaving adverse credit actions to hurt them. It's to the extent that's too prejudicial, then it's extremely prejudicial for the appellants, Ms. Faulkner and Ernest Faulkner, for the argument to be that, hey, we did everything we could, and what else did you expect us to do? Well, we would expect you to remedy that adverse credit action.
And what was the adverse credit action in this case?
It was for, the exact amount was $43,282.66. So the value that they said was remaining on the house, they did it as an adverse credit action to the Faulkners and left it that way on their credit, although they were able to represent to the jurors that, look, we realized we made a mistake. Everybody makes mistakes. We gave them the house free and clear. What else do they want?
Well, once they release the loan, that they report that to the credit bureau?
Yes, and they left it that way, and that's an undisputed fact that I was not allowed to bring up. And so that goes to the good question, that goes to their intent, that goes to whether or not it was an honest mistake, it goes to all of those things, and I was excluded from talking about that because I was told that was too prejudicial for them. And then on the next breath, they were then able to argue as if they did everything they knew to do, so that the jurors got this picture of, look, we made a mistake and we really tried to fix it. What else could we have possibly done? So that was the narrative that got to go forward without me being able to appropriately challenge it on that issue. And that issue also goes to damages, because we had to determine what the value of the house was. That's one of the things the jurors have to determine. Well, if they're leaving it on their credit as a negative adverse credit action for that amount, at a minimum, that creates the argument that even they believe that that's the value of the house. So they were able to argue, hey, the house was only sold for $4,000 in order to represent, hey, if you do find damages, the value is extremely low here. But the reality of it is they are representing that the value is $43,282.66. So even from that perspective, we should have been able to talk about it. And at a minimum, once the defendant opened the door and start making these arguments, then we should have been able to talk about it. The brief goes through all the different times we should have been able to bring it up, even if this court believes that initially it was proper to exclude it, which we'd ask you not to find that because we don't believe the evidence support that. But even if you were to believe that, the door got opened and reopened so many times, and every time we were not allowed to touch it, only the defendants were able to use that to an argument to their advantage.
What were the damages for your client?
So the adverse credit action is the damage, because part of the damage is the fact that they now have this adverse representations on their credit. In addition to that, as we go in, there were...
And what proof did you put on to show how they were affected by this?
So we weren't able to get into it at all. So we could not put on any proof. But in addition to that, that ties me into my other argument, we also had a claim for wrongful foreclosure, which would have allowed, we also asked for emotional damages, by the way. So that's part of the brief. But wrongful foreclosure, which would have allowed for emotional damages as well, was something that we were not able to get into because in that ruling, the judge initially granted us summary judgment on wrongful foreclosure. So there's no dispute a wrongful foreclosure happened. But then later...
You're talking about conversion, is that what you're saying?
No, a wrongful foreclosure actually happened as well. In other words, there was summary judgment granted in the plaintiff's favor for wrongful foreclosure as an undisputed fact.
That, as I understand it, that was initially because the court understood that your wrongful foreclosure claim was filed as a contract cause of action, and that later on, when you were arguing about the wrongful foreclosure, you wanted to argue about emotional damages and whatnot, and you argued that it was damage to real property and that it was now, that you were arguing that really what you were arguing was wrongful foreclosure as a tort action.
Yes, because what we had was a breach of contract claim. That was the contract claim. There's a separate claim we had, a breach of contract, and then another claim for wrongful foreclosure, two distinct claims, although they overlap a lot.
Well, the court understood initially that this denied summary judgment, though, because it understood that you were filing, as I understand it,
mm-hmm.
that you were filing it as a contract claim. You later then said that, no, you were filing it as a tort claim, and you wanted to be able to argue for emotional damages.
Correct.
And the judge then changed her opinion about that because she said since you're now arguing it as a tort claim, the other side said, well, the statutes run now on the tort claim because it was a 3-year, I think a 3-year statute. You said
correct. There was a 3-year, there's a 3-year.
So that's why she changed her opinion on it.
Correct. But my point is, and I understand that, but that there's no dispute that there was a wrongful foreclosure. The dispute is, did the 3-year statute of limitation run, which, as your honors, as I cited in my brief, even under the undisputed fact, it's one of the disputed facts that says, therefore, plaintiffs were put on notice at the latest by April 10th, 2012. Basically about these issues. So if you do 3 years from April of 2012, that does not run the 3 years, even under the argument of the 3 years. It doesn't run because this was filed in 2014.
Well, again, my understanding was that your client became aware of this wrongful sale or whatever as a result of a telephone conversation that it had with the mortgage company. And that occurred in 2011, I think in October of 2011, which was prior to the time that the lawsuit was filed 3 years later.
And I understand it's going to rebuttal time, but I want to address that because that's the dispute. It's our position that was a jury question because even after that happened, they continued to make representations to Tennessee Consumer Protection and to my client that, no, we reviewed it and there were no irregularities. So it's disputed that they would have had, that's absolutely our position under the case law. It's I don't even think it's a gray area. That's a jury question, especially when you have as an
All right.
undisputed fact.
You've answered the question.
Okay.
Any other questions, gentlemen? All right.
Thank you.
You've got your rebuttal time, Mr. Teague. We'll hear from the appellee.
Good morning.
Good morning.
May it please the court, Lauren Roberts on behalf of Nationstar Mortgage, the appellee in this matter. Put simply, there was no error in either the jury verdict, any of the evidence presented at the jury trial of this matter on the sole issue of fraudulent conversion of the property, and there were no issues in the ruling by the court on the motion for summary judgment in this case that would warrant any type of reconsideration or reversal, and Nationstar respectfully requests that this court affirm the trial court's orders in this matter. As you know, there are three...
Let me ask you a question.
Yes, Your Honor.
What claim went to the jury?
Pardon?
What claim went to the jury?
The sole claim that went to the jury was a claim for fraudulent conversion.
Fraudulent conversion?
Yes, sir.
Okay. Now, opposing counsel has argued extensively that adverse credit effect essentially should have been allowed to be presented to the jury. How does that relate to the claim that went to the jury?
It doesn't relate to the claim that went to the jury, Your Honor. The sole reason that adverse credit actions were part of this case at any point was that in the amended complaint, there was a claim made for violation of the Fair Debt Collection Practices Act. That act obviously meant that adverse credit actions, credit reporting in general, was part of the discovery in this matter. When the ruling went down on the motion for summary judgment in favor of Nationstar granting dismissal of the claim for violation of the Fair Debt Collection Practices Act, Nationstar moved in a motion in limine to exclude references to adverse credit actions from the trial of the matter, and further moved during the trial itself in objections to exclude that because it was unduly prejudicial, and it did not go to any of the issues in the case. As Your Honors know, a claim for conversion is defined as the taking or appropriation of tangible property to a party's own use to the exclusion or in defiance of the owner's rights, and that's citing to the Pomeroy v. McGinnis case from this court in 2021. That's tangible property, and tangible property is defined as something that you can hold, you can touch. It is not amorphous credit reporting data in the cloud type of information like credit reporting would be. So you cannot convert someone's credit report. There's no law out there that says that you can convert someone's credit report or credit score. Moreover, the damages associated with a claim for conversion is the fair market value of the property at the time and place of the taking. The credit score, the Faulkner's credit score, anything with regard to the Faulkner's credit report is wholly unrelated to the fair market value of the property at the time of the taking. There was argument by plaintiff's counsel a moment ago about how he was unable to present the $43,000 amount at trial, but that's simply not the case. There were several different claims as to the potential fair market value of the property that were presented at trial. One of those being the $4,000 that was paid by Blue Spruce entities as part of this erroneous bulk sale of property for the property in 2011. The second value would be the broker's price opinion that was generated by Nationstar in the spring of 2012 prior to the release of the deed of trust, and that was a $15,000 broker's price opinion. And the third potential amount of the fair market value was the $43,000 and change that was the outstanding balance on the Faulkner's loan at the time that the loan was written off and the deed of trust released. So the jury was presented with three different potential fair market values for the property should it have found that the property was in fact converted. However, the first question on the jury verdict form that the jury was confronted with was, what did you find that there was a conversion of the property? And that's not the exact wording, but that was the essence of the first question. And the jury found that there was no conversion of the property. So it did not reach the question of damages, though it was presented with 3 different potential amounts for that amount.
Let me ask you a question. So, as I understand it, the position is that this adverse credit claim or reporting claim, this arose under the Fair Debt Collection Practices Act, which was summary judgment was granted
Correct.
on that because of the statute of limitations.
That's correct. The statute of limitations had run prior to the claim being filed.
Okay. And that was the basis of the motion in limine to keep out the testimony regarding the adverse.
That, and that it was a prejudicial fact because it was unrelated to the damages, and so there is nothing probative that would come from testimony that there had been some type of adverse action because it could not impact the damages that were available for a claim of conversion.
Which is the fair market value of the property.
Which is the fair market value of the property at the time and place of the taking under the Lance Products versus Commerce Union Bank case. There were 3 issues raised by plaintiff's counsel in the briefing in this case, and the 3 issues amount to the jury verdict for the fraudulent conversion and the bulk of that going to this issue that we have just discussed about whether or not this adverse action on the credit should have been admitted at trial. It also touched on the jury verdict form itself and the jury instructions. Simply put, the jury instructions and proposed alternative form that plaintiff is proposing the court consider were never made part of the record. There was some argument made during the charge conference in this case that there should be nominal damages allowed for the conversion claim, or that the jury should be entitled to consider an award of nominal damages in considering the verdict. There is absolutely no case law that supports a finding that nominal damages are available for a claim of conversion. Again, the case law is very clear, the Lance Products case and others, that the damages available for a conversion claim are the fair market value of the property, not some type of nominal damages or emotional damages.
Let me ask you about the verdict form.
Yes, Your Honor.
It simply says, do you find that Nationstar converted plaintiff's real property? Was that verdict form agreed to by both parties?
I believe it was.
And I notice it doesn't use the language wrongfully converted, fraudulent converted. Any reason why that language was not used?
It is my understanding, Your Honor, that in order for them to have gotten to the issue of whether the conversion itself was somehow inappropriate, they would have first had to find whether a conversion occurred at all. And because they did not find any conversion occurred at all, anything further with the verdict form is simply irrelevant.
Okay.
The second primary issue raised in plaintiff's briefing relates to the summary judgment itself. And as Your Honors have heard briefly this morning and have realized from the briefing, this has a bit of a tortured procedural history in this case, in that there were originally cross motions for summary judgment filed on the amended complaint, and the court awarded a judgment in favor of Nationstar on all of the claims that are believed to exist in the amended complaint, with the exception of wrongful foreclosure at the time of the first order on the summary judgment. And I would like to touch on something that plaintiff discussed in his oral argument, which is this idea that the amended complaint somehow incorporated the original complaint, and that all of those claims came into and became part of the amended complaint. It's my understanding that an amended complaint completely subsumes the original complaint, supplants the original. The only claim that existed in the original complaint itself was a claim for fraud. That claim was not repled in the amended complaint. The claims in the amended complaint were for wrongful eviction, violation of the Fair Debt Collection Practices Act, breach of contract, negligence, negligent and/or intentional infliction of emotional distress, and wrongful foreclosure. Fraud was not something that carried over and was part of the amended complaint. Even if it had been, it was not filed timely pursuant to the statute of limitations, but just touching on that comment by plaintiff's counsel during his argument.
He said there was incorporation language. Was there incorporation language?
I don't believe that there was incorporation language as we sit here today. But nonetheless, all of the claims with the exception of wrongful foreclosure were granted in favor of Nationstar. The wrongful foreclosure claim was initially granted in favor of the plaintiff, with damages being obviously held for later adjudication at trial by the jury. Prior to this getting to jury trial, as Your Honor has recognized, Judge Golden, during pretrial briefing, for the first time, plaintiff's counsel advised the court and myself that the claim for wrongful foreclosure was not a claim sounding in contract. It was a claim sounding in tort. It was a tort claim regarding the real property, making it subject to a 3-year statute of limitations. At that time, we filed an amended new motion for summary judgment, asking the court to reconsider its previous ruling on the summary judgment and in fact grant summary judgment in favor of Nationstar on the tort-based wrongful foreclosure claim because it violated the statute of limitations. There was some discussion earlier regarding the discovery date. It was found by the court, and I believe it is unchallenged and in the statements of material fact, that Ms. Faulkner discovered the issues with regard to her property and her loan in October of 2011 during conversations with Nationstar representatives on the phone. What's more than that, Ms. Faulkner filed a claim with the Tennessee Department of Financial Institutions, filed a complaint in early December of 2011, and did not file her actual complaint with the court until late December of 2014. So even if there's challenge to this phone call and what Ms. Faulkner may have learned with this phone call, she knew about the issues and was able to file a complaint with the Tennessee Department of Financial Institutions well more than 3 years before she filed her complaint with the Shelby County Circuit Court in late December of 2014. The final issue raised by the plaintiffs in their briefing is with regard to the court's exclusion of evidence of emotional distress. It's unclear to me from the briefing exactly what part of the proceedings there was belief that this evidence of emotional distress should have related to, but I believe they are saying that it should have been provided at trial, that there should have been testimony regarding the emotional distress that was part of the trial. Again, the issue on trial, the sole issue on trial, was a claim for fraudulent conversion. It does not relate to the damages. Emotional distress does not relate to the damages available for a conversion claim, the fair market value of the property. Once more, the claims that did provide for testimony regarding emotional distress, and that would be the negligent and/or intentional infliction of emotional distress claims specifically, those were dismissed by the court in the ruling on the summary judgment because of violation of the statute of limitations. The final way that opposing counsel was hoping to, or appeared to intend to introduce evidence of emotional distress, was through the claim for wrongful foreclosure, citing to the Miltier versus Bank of America case. I may be butchering how that's pronounced, the Miltier versus Bank of America case. But in making that statement to the court that the wrongful foreclosure claim was that he was proceeding as a tort-based claim in order to get in that emotional distress damage, it became subject to the statute of limitations. Should that claim have proceeded as a breach of contract claim, emotional distress damages would not have been available, cannot receive emotional distress damages for a breach of contract, and thus it would not have been proper to introduce it under that standard either. For all of these reasons, despite the confusing record in this case, it is clear that the court was appropriate in granting summary judgment in favor of Nationstar on the claims for wrongful eviction, FDCPA, breach of contract, negligent and/or intentional infliction of emotional distress, and wrongful foreclosure, and that the jury verdict in favor of Nationstar on the claim for fraudulent conversion was further appropriate, as were the rulings on all the evidentiary issues, both pre-trial and at trial itself. And Nationstar would ask that the entire lower court ruling be affirmed in full. Thank you.
Thank you. You have 3 minutes, Mr.
Thank
Terry.
you. I'll be swift, precise, and exact. First, no, the appellants did not agree to the verdict form, which is why we submitted our competing verdict forms, because again, if the claim is fraudulent from conversion, we necessarily have a right to talk about the fraud and fraudulent conversion. So that's just not true, and the record will show that that statement was incorrect. In addition,
Are your jury instructions part of the record?
we attached it as in the motion for new trial, because at one point in the hearing, and there's a transcript, the court seemed to suggest that we did not submit things of that nature, so we actually incorporated the emails that went to the judge and the transcripts where we talked about it. And at the motion for new trial, we said, Judge, if you challenge any of this, make findings of fact and put it in the record so that the appeal court can know what your issues are, because this is what happened. And it was not challenged or confronted in any way. As it relates to this adverse credit action, again, another false statement that was made was that it was only part of the amended complaint in the Fair Debt Collection Action. Completely false. Volume 1, pages 1 through 4, specifically talk about the adverse credit action as it relates to fraud. So that's undisputed by the record. As far as the language being incorporated from the original complaint to the amended complaint, that absolutely happened, and that can be found in Volume 3, pages 384 to 390. So there's no real question that happened either. The other issue about not knowing that we weren't going forward on the breach of contract element and just a tort, I think that argument is a little disingenuous, because if you look at the initial order on summary judgment, the breach of contract claim was dismissed by the court. So we could not go forward on the breach of contract claim based on our dismissal, and it was dismissed by the court because they said that there was no contract attached. The problem with that argument is prior to the court saying that, they found as an undisputed fact, that the defendants instituted a formal foreclosure, did not institute a formal foreclosure proceeding as required by the deed of trust and state law. So there was already an undisputed fact that there was a breach of contract, but yet the judge still dismissed the claim for not having the contract, which was attached to the motion for summary judgment, but there was already an undisputed fact that there was a contract that was breached. So yet we could not go forward at that stage under the breach of contract because the judge had already said we couldn't. So there should not have been a genuine confusion as to why we weren't going forward. We were told we could not. And we disagreed with that because, again, we think it's obvious if you treat it as an undisputed fact that there was a breach.
Wait a minute, you said that the wrongful foreclosure was initially, that the summary judgment was granted on that?
The summary judgment for the breach of contract was granted because the argument by the court was there was no contract attached. But in that same order, when you read it, the court says as an undisputed fact, the deed of trust was violated, was breached. So we didn't have to attach it, even though it was attached to the summary judgment motion, we wouldn't have to attach it when it's an undisputed fact.
In the order granting the motion for summary judgment as to certain claims and making a determination about what triggered the running of the statute of limitations, there's certain facts set out in the order. One being that this supposed purchaser came out to the property in 2011,
Correct.
placed a sign on the property indicating that they were the new owners. In
Correct.
addition, a telephone call was made by your client's daughter to the mortgage company in 2011. Further, in 2011, you filed a complaint with a consumer complaint with the Department of Financial Institutions in 2011.
Correct.
Why would that not have triggered the running of the statute of limitations in 2011?
Because
as opposed to your argument that
Well,
it's 2012?
Well, because the court in that same order says that the latest the plaintiff would have known was by April 10th, 2012, and because when the Tennessee Consumer Act reached out to the defendant to clarify it, they said there were no irregularities with this. Basically, nothing wrong happened. So they doubled down and made that representation again in 2012. And the court, again, in that same order, it says the latest the plaintiff would have known is April 10th, 2012. So if that's the court's ruling, I don't know how we don't then make that a jury question, because that's the court's own order saying that that's the latest she could have known.
All right, thank you. Thank you, counsel. We appreciate your argument. We will review the record, the briefs, and attempt to get you an opinion at the earliest possible time. Ms. Angie, you may